Just looks like cocaine. Oops.
I wish I could get that light out of there.
All right, everybody. Welcome to. We're going to be going over Colburn's lawsuit and Netflix reason for dismissal. I have Christy with me, Jamie, Big Jeff, Obi-Wan will be here eventually, I'm assuming. But yeah, let's get to it.
Okay, you're gonna put the filing up on the screen. I'm gonna read along. I am gonna skip some parts. We're not gonna read it word for word. It is a little lengthy, it is a little repetitive, but I'm gonna try to hit all the good points. Okay, it starts off, Andrew L. Colburn, a sworn law enforcement officer, brings this lawsuit over a documentary television series that uses the unique experiences of Stephen Avery, a DNA exoneree charged with murder, to provide a window into the American criminal justice system. Taking viewers from Avery's 1985 wrongful conviction for rape through his 2005 arrest and prosecution for murder, the series explores whether 20 years of scientific advances and legislative reforms have resulted in a more reliable system. As is obvious from even this brief summary, as well as the nationwide contemporaneous media coverage of Avery's prosecution and trial, the series titled Making a Murderer explores issues of the utmost public interest and concern. Given the subject matter of making a murderer and Colburn's status as a public official, to prevail in this defamation case, he must plead and prove the defendants published the documentary series with actual malice, either knowing it was false or despite a high degree of awareness of its probable falsity. Even if Colburn were not a public official, he would still be obliged to plead and prove that the defendants negligently disseminated a material falsehood against him. With regard to defendant Netflix Inc., however, Colburn's amended complaint comes nowhere close to satisfying federal pleading standards. Instead, he simply lumps Netflix together with co-defendants Chrome Media LLC, the conceitedly independent production company that created Making a Murderer, and its filmmakers Laura Riccardi and Moira Demos, and makes vague, conclusory allegations on information and belief, no less, about defendants collectively. Setting aside all the other problems with Colburn's lawsuit, most fundamentally that Making a Murderer contains no false statements of fact about him, he has not plausibly alleged that Netflix distributed the documentary series negligently, much less with the requisite actual malice. All his claims against Netflix should be dismissed pursuant to Federal Civil Procedure 12b-6. It goes through the history. Colburn commenced the lawsuit in December of 2018. It happened to be one day before the statute of limitations expired. He filed the complaint against Netflix, Chrome, Riccardi, and Demos. He later amended his complaint and changed his 3 causes of action as defamation, actual malice, negligence in the affirmative, and intentional infliction of emotional distress. He also dropped several defendants, leaving only Netflix, Chrome, Riccardi, and Demos. It just goes on about his different amendments and what they agreed on the extension and the date that it was due. Netflix now brings this motion to dismiss under Federal Rule of Civil Procedure 12b-6. It seeks dismissal with prejudice because Colburn has not plausibly alleged that Netflix acted with the requisite degree of fault in distributing MAM, and because a Second Amendment complaint would be futile. Colburn's allegations against Netflix. The gist of Colburn's amended complaint is that MAM, which chronicles Avery's wrongful conviction in the 80s for a crime he did not commit, his exoneration and release after 18 years in prison, his filing a $36 million civil rights lawsuit against Manitowoc County, its former sheriff and district attorney, and his subsequent conviction, along with his nephew Brennan Dassey, for the 2005 murder of Teresa Hallback, defames Colburn in retelling that story. As Colburn concedes, Avery's defense at his murder trial was essentially that Colburn and another sheriff's deputy, embarrassed by their role in the botched investigation that led to Avery's wrongful conviction and facing his civil actions, planted evidence to ensure he was convicted a second time. Colburn objects, however, to the series' recounting of that theory. He alleges that by selectively editing trial testimony and by purportedly taking his statements and actions out of context, defendants misled viewers into concluding Avery is innocent and Colburn is crooked. More specifically, Colburn, a sworn law enforcement officer who both participated in the investigation of Hallback's death and testified at Avery's trial, complains that MAM's portrayal of 3 issues, Of the 3 issues he concedes were addressed at Avery's trial. 1, a telephone call Colburn received while serving as a corrections officer at the Manitowoc County Jail. 2, a communication he made to dispatch regarding the license plate number on Hallback's car after she disappeared. And 3, the discovery of the key to Hallback's car in Avery's home. He goes on to talk about how Netflix was involved with this with actual malice because the producers of the show had access to the entire trial because they were there. They had access to police reports. He basically alleges that they had all the information they needed to not put forth these bogus statements. Hang on one. Can you, Obi's, I gotta send Obi. Obi needs the link. He's not seeing it. No, Lily. I know. I'm getting him right now. Okay. He goes on to point out specific things that Riccardi and Demos specifically did as far as splicing his testimony or splicing together pieces of trial video.
It's called editing. That's what they did with this case as an investigation.
They did. They edited. Yeah, the police edited. They don't like it when people edit them, huh?
No.
Okay.
Well, I mean, just watch any political channel you like, whether you prefer MSNBC or Fox News, and look at the politicians that they don't like and the goofy pictures that they show of them when their faces are sort of mid-speech, right? That's really no different what they did to Colburn. They're saying, well, they took deliberate pictures of him when he was looking concerned or confused. Well, that's what they do to every political candidate on Fox News, MSC, the Washington Post, the New York Times. If they don't like somebody, you put them in a goofy-looking position, and that's what they did to Colburn. Sorry, that's the way it is. When you're a public figure, you can do that.
Absolutely, absolutely. But he alleges he's not a public figure, but Netflix alleges that he is.
No, as a sheriff's deputy, you're definitely a public figure.
As it states in here, and Millbilly put the link up, so if anybody wants to actually read this word for word, it is available out there. You can click on it and read it for yourselves. Let's see.
I think we should move on to the exhibit.
Yeah, one more thing I had, Millbilly. I was taking a note as Christy was reading. Didn't Stephen get charged in 1985 with attempted murder as well? They just talked about rape. I thought he also got charged with attempted murder.
That's correct too.
Yeah, so I think that
arrested him for, and then
Obi-Wan is here, Millbilly.
And then they requested that he have a DNA rape kit done, whatever they call it, on him. And even the officer was questioning, like, well, if he's being arrested for attempted murder, why are we doing this for him?
Right. Yeah, I think we can skip a lot of the filing. He just alleges that, we know what he alleges. He alleges that he didn't call in the plate before officially finding the RAV. He alleges that was all spliced together. He alleges that they took answers to one question and spliced it in with the answer to a different question just to make him look guilty, that they used selective facial expression. So he just goes on and on and on. And Netflix obviously fires back and says no. And then just recently we find all these exhibits that Netflix has submitted. So what I have in front of me now, are you going to pull this up on the screen? Okay, this is the second declaration of Matthew E. Kelly. I, Matthew E. Kelly, under penalty of perjury and subject blah, 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 declare as follows. I am one of the attorneys for the defendants in the above captioned action. I have personal knowledge of the matters set forth herein. I make this declaration in support of defendant Netflix Inc.'s motion to dismiss plaintiff's Second Amendment complaint. Numbers 2 through 11 are simply exhibits 1 through 10 that are copies of episodes 1 through 10 of Making a Murderer.
Season 1.
Yeah, it's basically season 1. Okay. Then we have number 12. Attached, Exhibit 11 is a true and correct copy of the document captioned as Correspondence Memorandum with a subject listed as Avery Review from Wisconsin Attorney Peg Lautenschlager to Manitowoc County District Attorney Mark Rohrer, dated December 17, 2003. This document sets forth the findings and conclusions of the Attorney General's investigation of the wrongful conviction of Stephen Avery in 1985. It was introduced as an exhibit in depositions of Manitowoc County officials in Stephen Avery's civil rights lawsuit. Number 13, attached Exhibit 12 is a true and correct copy of the transcript of the deposition of Mark Rohrer, Part 2, on September 22nd, 2005. Number 14 is attached to Exhibit 13 is a true and correct copy of the transcript of the deposition of Michael Griesbach on September 22nd, 2005. The highlighting appears on the copy of the transcript in the defendant's possession. 15 is Exhibit 14 is a true and correct copy of the transcript of the deposition of Andrew Colburn on October 13th, 2005. Number 16 says attached is Exhibit 15 is a true and correct copy of the statement of Andrew Colburn dated September 12th, 2003 regarding the telephone call that Colburn received as a corrections officer at the Manitowoc County Jail in 1995. It was introduced as an exhibit in depositions of Colburn and other Manitowoc County officials in Stephen Avery's civil rights lawsuit. Netflix has redacted personal identifying information. Number 17, attached is Exhibit 16 is a true and correct copy of the transcript of deposition of Manitowoc County Sheriff Kenneth Peterson dated October 13th, 2005. Exhibit 17 is a true and correct copy of the transcript of the deposition of Manitowoc County Sheriff Lieutenant James Length on October 11th, 2005. Exhibit 18 is a true and correct copy of a memorandum from Douglas K. Jones to Mark Rohrer regarding Stephen Avery filed case number unknown, dated September 18th, 2003, on the letterhead of Manitowoc County District Attorney. In this memorandum, Jones, an assistant district attorney, describes a conversation he had with former Manitowoc County Sheriff Department Chief Investigator Jean Couchet regarding Couchet's conversation with Andrew Colburn regarding the call Colburn received at the Manitowoc County Jail in 1995. It was introduced as an exhibit in depositions of Couchet and other Manitowoc County officials in Stephen Avery's civil rights lawsuit. Exhibit 19 is a true and correct copy of the transcript of the deposition of former Manitowoc County Sheriff Chief Investigator Eugene Couchet, also known as the Pencil, on October 26, 2005. Attached to Exhibit 20 is a true and correct copy of excerpts from the book by Plaintiff's Counsel Michael Griesbach, The Innocent Killer. Number 22 is Exhibit 21 is a true and correct copy of a case activity report for case number GC 13280, dated September 30th, 2003, by the Wisconsin Division of Criminal Investigations Special Agent Deborah Strauss. The report's activity is listed as records examination safe documents, and it describes Sheriff Kenneth Peterson allowing Strauss to review documents stored in the safe in Peterson's office, including the September 12th, 2003 statement by Andrew Colburn, attached here as Exhibit 15.
Now, you got to remember, Stephen Avery is released from prison on September 11th.
And Colburn is writing a report the next day from something that happened 8 years prior.
Yep.
That's about his normal speed, though. I don't think that should, necessarily be held against him as something atypical, right?
Yeah, pretty
Typical
much.
for him. It's not typical for the rest of the world. It's not how it should have gone.
Well, the question is,
Another thing it brings.
to file that report. Just like he's not instructed to file a report of what happened on November 3rd, 2005, until they do the summary of the Manitowoc.
And does it not make you question, why does Peterson have a special file in a safe in his office about Stephen's case?
Yeah.
Good question.
There was a lot of private things and files hiding around, and
Yeah, I guess. One other point that's probably worth bringing up too is that Stephen Avery was suing some of these people individually as individuals, All of that's been mentioned so far
Well,
is his
technically,
case against Manitowoc. But he
it
was
all-
suing some of them.
It all became, he was suing 3 people. 3 people were being held liable. Do we all know who they are?
Peterson,
Kasarik and Vogel.
Ding, 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 ding.
We
So
only
do you
needed 3
think that-
guesses. That's not bad.
We got it all right on the.
Why would Strauss need to review those files?
Well, Peg obviously sent her in there.
Yeah, Jeb Strauss's name was on the Lautenschlager report.
Uh-huh.
So she had to review it to write the report, I assume. But there was nothing in the. I read that report, and there's nothing in that report about Peterson's private file.
Sure.
Nice.
All right, we got number 23, exhibit 22.
Well, yep. Is a true and correct copy of a search warrant and supporting affidavit dated November 5th, 2005, from the Circuit Court for Manitowoc County. The warrant authorizes searches of the homes of Stephen Avery and Barb Yonda and the 40-acre premise of Avery's Auto Salvage. This is the first search warrant approved in the Hallback investigation and was drafted by plaintiff's counsel Michael Griesbach, who was then a Manitowoc County Assistant District Attorney. Exhibit 23 is a true and correct copy of the decision and order on defendant's motion to suppress evidence based on multiple entries under November 5th, 2005 search warrant filed on December 12th, 2006 in the Circuit Court for Manitowoc County. Exhibit 24 is a true and correct copy of the decision and order on state's motion to exclude blood vial evidence filed on January 30th, 2007. Exhibit 25 is a true and correct copy of the memorandum and order granting defendant's motion to dismiss in Fairfax versus CBS Broad, Inc. Exhibit 26 is a true and correct copy of excerpts from the book by plaintiff's counsel Michael Griesbach, Indefensible. Number 27 is a true and correct copy of the decision and order on state's motion to allow the introduction of 9 items of other acts evidence filed on September 25th, 2006. Exhibit 28 is a true and correct copy of a portion of the transcript of arguments and testimony on February 12th, 2007, day 1 of the trial in State versus Avery. The exhibit includes the opening statement of defense counsel Dean Strang and the testimony of witness Michael Hallback, a brother of the victim, Teresa Hallback. Exhibit 29 is a true and correct copy of the transcript of proceedings on February 20th, 2007, day 7 of the trial in State versus Avery. This transcript includes testimony from Sergeant William Tyson of the Calumet County Sheriff's Department, Sergeant Andrew Colburn of the Manitowoc County Sheriff's Department, and the plaintiff in this action, and Lieutenant James Lank of the Manitowoc County Sheriff's Department. Exhibit 30 is a true and correct copy of portions of the transcript of testimony on February 21st, 2007, day 8 of the trial in State versus Avery. This transcript includes the continuation of the testimony of Lieutenant Lank and the testimony of Detective David Remaker of the Manitowoc County Sheriff's Department. Exhibit 31 is a true and correct copy of portions of the transcript of testimony from February 22nd, 2007, day 9 of the trial in State versus Avery. This transcript includes the testimony of Deputy Daniel Pacharski of the Calumet County Sheriff's Department and Special Investigator Gary Steer of the Calumet County Sheriff's Department. Exhibit 32 is a true and correct copy of portions of the transcript of testimony on February 23rd, 2007, day 10 of the trial in State versus Avery. Transcript includes testimony of Wisconsin State Crime Lab forensic scientist Sherry Colhane, our favorite. Exhibit 13, true and correct copy of portions of the transcript of testimony from February 28th, day 13. The transcript includes a testimony on direct examination of Special Agent Tom Sturdivant of the State Division of Criminal Investigation and forensic anthropologist Dr. Leslie Eisenberg. Exhibit 34 is a true and correct copy of the portion of transcript of closing arguments on March 14th, day 23. This transcript includes the closing argument of defense counsel Jerome Buting. Exhibit 35 is true and correct copy of portions of the transcript of closing arguments from March 15th, day 24 of the trial. Transcript includes the closing argument of defense counsel Dean Strang and the rebuttal closing argument of Special Prosecutor Kenneth Kratz. Exhibit 36 is a true and correct copy of the transcript of proceedings on March 18th, 2007, day 27 of the trial. This transcript includes the reading of the jury's verdict. And those are all the exhibits that were attached to Netflix's motion to dismiss.
And we have all the exhibits to go through.
We do.
Question is, start at,
Where do you want to start?
well, one that always popped out at me.
Are you looking for the one that we talked about, Millbilly?
Well, we talked a lot about a lot of them.
The Fitzgerald
But
one?
no, that not yet. Let's see, where is it?
So when Millbilly starts going through some of the exhibits, there's a few things to pay attention to, and that's what he's trying to pull up for people to see. There, I don't know if you want to call them anomalies or they're just items of interest.
Well, yeah, I guess we could go to Greasebox because let's see.
His deposition or the pieces of his book?
No, the deposition. Yeah, well, that's the one I'm thinking of.
Okay. That should be number 13.
All right. Loading.
And I apologize. I don't have YouTube open, so I don't know who's here. So, hi everybody who's here.
I'm watching the chat. So we've got Jamie Van Hout, Be Happy, Shaz, Mary, Bob Bailey, Linda, Darkside.
Well, hi everybody.
Travis Williamson is here. Donna Marie. And,
We got exhibit 13. No, we're not going to read.
Do what?
I just want to point out a portion. So I want to read out the whole. I just want
Yeah,
to
I haven't had a chance.
It doesn't make.
I haven't had time to read
There's
any of
videos
these
for all
depositions
these
yet.
depositions.
Right.
Basically, script on. We all know that was going to be.
And I just want to be I just want to be clear that these exhibits that we have right now are from the Netflix. These came with this court filing. These are not the ones that were gotten by the recent GoFundMe FOIA request that went out.
And so I was talking a little bit in the chat here with Travis earlier, and I want to see if I can find what he had mentioned that the major victory Netflix got out of the motion to dismiss was that Colburn conceded that he is a public figure, as we were talking about earlier.
So what do you? I guess I didn't pay much attention to this when it first happened because I really didn't think it was going to go very far. I was quite shocked when an evidentiary hearing was granted. So I'm interested, Travis, on what your thoughts are there as far as where you think this will go. What do you think? What do you think will happen? I'm going to open up YouTube too.
Yeah, that's how I'm looking at it. I'm actually on a tablet, so I can see what people are saying too. I didn't want to disrupt disrupt the call. But now that we're wait here a little bit for Millbilly to get that pulled up.
Right in here. I mean, there's lots of info. If you read through this whole thing, they talk about a bunch of people.
Travis says, well, there is a couple of things going on.
Well, and it seems like Griesbach seems to say the same thing over and over. I don't recall. I don't recall. I don't recall.
Julie Fearater wants to know where we're from and if we have jobs.
So this isn't, okay, so if I understand what Travis just wrote, so this is actually, and I'm definitely behind on this case, period. So this is a new motion. This is a motion to dismiss after the evidence, after they granted an evidentiary hearing? Is that what you're saying?
Why can I not find this now?
What are you trying to pull up?
The portion of how Mark Rohr got his job. Oh, that's why, because I'm in the wrong one.
Well,
It's
that
in-
helps.
You go to Rohr.
It's in Mark.
Funny that Griesbach can't remember anything, but he wrote 2 books on the topic, right?
Yeah. Well, it always seems like anybody that's official gets to answer things with, I don't recall.
Right.
But
Travis, do you just want to join us? Would it be easier to bring you in here and let you talk? We can do one more, can't we, Millbilly?
Yeah.
Travis, you want to just come in
that's
here?
fine.
There you go, Jamie. Can you grab him the link off the? Oh, I'll do it. I should be able to do it. I should still be able to message him. Copy link.
Yeah, I'd also love to hear your thoughts, Travis, on the copyright statement that was issued with the recent GoFundMe purchase. That seems to be claiming some type of copyright over these records, which appear to me to be, in the public domain. So why should they have some type of copyright that prevents this, mass showing of them all in one place?
Right.
What's that all
We
about?
got the definition of Mark Rohr. Now, this is the thing that made no sense to me.
Oh, I'm a moderator. I can hear Travis. Here's the. Click that StreamYard link, Travis. Please, nobody else click that.
They can all click all they want. I have to invite him into the studio. Well,
before Travis comes in, did you find that statement about Fitzgerald yet? Or are you still looking for it?
Statement
It's
about
coming up.
Fitzgerald. Oh.
Hey, Travis.
Hi, Travis.
Hey. Hi, everybody.
Hey, bud.
Hey,
Good to see you.
good to see you all.
Good to talk to you again, Travis.
Yeah.
Yes, thank you for coming to explain this.
Oh, thanks for inviting me in. It's really hard to explain
That's
civil
why I
procedure.
figured it was going to be hard typing.
Yeah, civil
my turn,
procedure with your thumbs is almost impossible. But I can explain the procedural background while Millbilly's looking for that, and then I can address the copyright issue if you want.
Okay. Yes,
Okay.
that would be cool.
Right here.
Okay, so I don't have the dates in front of me, but generally the progression was they filed a lawsuit right before Christmas a year and a half ago, right before December of 2018,
Right.
And
Yes.
so one law firm represents all of the defendants. We can get into that later if you have questions about that. But they filed what we call on behalf of Netflix, a 12B6 motion. It's a Rule 12 of the Federal Rules of Civil Procedure. It's a motion to dismiss. It's very, very difficult to get. It's only if somebody in their complaint fails to allege something legally. Their complaint is deficient on its face. And Netflix filed a motion to dismiss. And then we have what we call the producer defendants, which is the two ladies that made the documentary and the name of their production company, which escapes me from Chrome Media. And so they also filed a motion to dismiss. That was based on lack of service, that they were served improperly, and that if they were served, that it was, I got to go get a phone charger. So if you see me walking around, apologize if it's distracting. But the lawsuit was filed on the last day of the statute of limitations. Every state has a time limit that you can file a lawsuit. If you don't file it within that time, you're out of luck. It's called the statute of limitations, and they filed it on the last day. There's also, under federal law,
Hey, Travis.
Yes.
Real quick on that, what do you think their reasoning is for waiting till the last day? Do you think this was, they'd been planning and building this since the first MAM came out?
No. Typically, when a lawsuit is filed on the last day, it typically, not always, and I've commented on this in the past, typically means that the plaintiff had a difficult time getting a lawyer or law firm to take the case. And that can be for a variety of reasons. One, that it doesn't have a lot of merit, or two, it's a very expensive case to litigate. But typically, cases that are meritorious, you don't wait until the last minute. Now, I don't know for sure, but
is that because you have ambulance chaser lawyers jumping out of helicopters to try and get their piece of the pie?
Right. I mean, if he had been complaining and, had talked to lawyers about it, but it doesn't mean necessarily that the case doesn't have merit. He may have talked to different attorneys and they just said, well, we really think you have an excellent case, but you're talking about going up against one of the largest media conglomerates in the world.
How ironic is it that Griesbach, of all people,
after a nationwide search, they find Michael Griesbach?
Yeah, well, my speculation is that the police officers union is funding this, and that any union, but police unions are no different. If you have a member of a union that could be a teacher, police officer, fireman, whatever, that is being attacked maybe or persecuted in some sort of way, and that if that officer, and we'll just limit it to police, if that police officer is being subjected to something that other members of the union could also be subjected to, the board of trustees of the union will there's a process every union has, and you submit it and say, hey, I'd like you to come in and fund this lawsuit because, if it can happen to me, it can happen to anybody. But I suspect that, I don't think Griesbach could go out of pocket for the amount of the cost that this case is going to take. And when I say cost, I'm talking deposition fees and just the out-of-pocket stuff that you typically are going to have. And you can see how much money it's probably costed both sides since. But, so I think the reason why they filed it on up to the last day, you really don't want to push it that long. You want to give yourself time. Usually, if you can, you file it at least 30 days before the statute of limitations, because that helps you avoid the situation the plaintiff is in with respect to the producer defendants. You only have a certain amount of time to serve the lawsuit. So you can file the lawsuit up to the last day of the statute of limitations. And the statute of limitations is based on when Netflix was released, and it was released in December before Christmas. The state, they filed it in state court originally, Wisconsin state court. And if the plaintiff resides in a state different than all of the defendants, so if there had been one defendant that was a Wisconsin resident or an Arizona resident, it would have stayed in state court. But because all of the defendants live in states outside of Wisconsin, you have what we call federal diversity jurisdiction. You can only move a case to federal court if there's federal jurisdiction. And one of the things that creates federal jurisdiction is diversity of citizenship. And so because Colburn filed in Wisconsin and Netflix is, I don't know if they're a Delaware corporation or a New York corporation, that's what state their citizenship is determined by, where they're incorporated. And then, of course, the producer defendants are all in LA County, California. So they had the option to move it to federal court, and they did. But then the time is ticking still on how quick they serve. Now, they clearly served Netflix timely, and they did that by serving a resident agent, which is just a person you designate when you incorporate that will accept service. The producer defendants, not sure how familiar you all are with that motion, but
this is the part I don't understand. Okay, Michael Griesbach runs for district attorney against Fitzgerald. Griesbach then wins. He then resigns. He doesn't take the position. And then Mark Rohr applies for it and gets it. How do you apply for an elected position?
Did that make sense, Travis?
what was the position that they said it was?
District attorney.
And I didn't hear the first part. Was the position vacated by somebody?
Okay, no, this is what happened. Fitzgerald and Griesbach, they ran against each other for the positions. Fitzgerald was rerunning to keep his position. Griesbach won.
Okay.
He then declined it. And then Rohr applies for the position and gets it.
To me, that seems like that's political.
Appointed by
Yeah,
government.
so, yeah, that would be appointing a vacancy. You'd know more about Wisconsin politics than me, Millbilly, but
Why did he run if he didn't want the position?
yeah, I don't know.
To me that just seems like they were playing a game of chess, because they were either blocking Fitzgerald from getting it, and it's almost like they were just directing who they wanted for the position. You know, it seems
That's not all of that. That's not all that uncommon in politics. It happens more frequently than you think.
And this is why
I don't know about that specific county, but you run different people against different people for a lot of reasons, and there's the party heads of the state or the county. There's a lot of strategy in that. Well, if we get this person to run against that person, that'll split the vote off, to that. But it could be for something more sinister. I just don't know. But you can't force somebody who's elected to be sworn in. And the other thing that happens is somebody is elected, and then something substantial happens in their life. They might get diagnosed with cancer. Now, I know none of this applies to Griesbach, but they're diagnosed with cancer, they win the lottery, whatever, and they're just like, yeah, no thanks. And then and then there's a process. Typically at that level, states do it a couple of different ways. The governor can appoint a DA. The local county commissioners can appoint, by majority decision can appoint somebody. But yeah, that is rather odd and interesting. I never knew that.
Yeah, we didn't know it either, I don't think, until the other day.
And it literally leads to, and Chase is on the board, even, saying that they're less than honorable in that county right now, and this kind of plays right into what we all think about how they went about this investigation, how they went about everything, and it seems to fall right in line with what this county is doing.
When was the election in reference to Stephen is released from prison September 11th of 04?
3. 03.
03. And when was the election?
I believe it would have been 2000. Which election are you referring to?
The one that saying Griesbach just won.
The one that Griesbach won.
That was after he was released.
Right. It was 2006, wasn't it? Or am I confusing that with when Colburn ran? 2004. 2004.
So
now,
how are they allowed to lie on a search warrant?
Are you changing the subject?
It's just the search warrant that they issued to the judge. They lie. Wiegert lies.
I'm hearing a lot of feedback.
Yeah, I'm not.
No, it's somebody's TV.
I was listening to you all. I just heard typical kids Saturday night commotion. I mean, that's we get that around my house all the time. Is what I was hearing.
He took office in March of 2003 as district attorney.
It was
So,
shortly after.
Yeah. So,
Takes a few months
yeah,
to
it's
run
hard to say. You know, that's predating everything. So obviously, one didn't have anything to do with the other. However, the points that I think Jeff was alluding to, and others have commented on, is that it's just that's particularly odd to have a contested election, which I'm not aware of any county in the country. It doesn't cost money to run for DA. And, you're asking friends and relatives and colleagues to contribute money to a campaign. If there's not a really good reason why, after asking for all of this money and you win, and then you turn down the position, I mean, unless there's a really good reason, that's political suicide to ever run for anything again. I mean, it's just common sense. They'd say, well, why should we give you financial support this time? The last time we backed you and walked door to door and made phone calls and raised money and threw parties and on and on and on and on, you declined the job. I'm whether his rationale is true or not, he would have had to lay down some sort of rationale why he wasn't going to take the position. But I'd really like somebody to explore that further, that might have some sort of contact with somebody that is in the political know, or just accessing the local newspaper there should be able to tell you what his reason was. And that, of course, would be significantly newsworthy. I can't imagine. I mean, any of you live in a county where if that happened, that wouldn't be,
it'd be highly questioned. It'd be highly questioned. People would want to know, and the reporters would be all over it, and it'd be on the evening
people that
news
voted for him. The people that
Yeah.
voted for him would want to know, what the hell? We voted for you. What do you mean you're not taking it?
Yeah.
And there was no follow-up in the deposition transcript about, hey, by the way, why is it that you declined the position? There was no follow-up questions.
I've
No.
not. I can't say with certainty at that moment.
Yeah, I think he's reading the Mark Rohr one, right? And the Mark Rohr one is how Mark Rohr got the job in the first place.
Okay, gotcha.
Yeah.
Okay, all right. Yeah, so there wouldn't be any follow-up. He was selected to be appointed, and he didn't care why. He just took the appointment, right?
Right.
Yeah.
Very much.
Hey, so moving on, 04 asked a question in the chat.
I move it.
She asked, how is it possible to get a search warrant after you've already searched a place?
Well,
the day
that wasn't the issue in Stevens.
They're initially
You
sent
can-
there to retrieve the computer.
Oh, well, yeah. So that you're talking about two different residences, and actually two separate pieces of property. But if you can lay out probable cause to a judge, either before someone's indicted or even after they're indicted, you can go back and apply for a search warrant as many times as you want if there's probable cause. However, a judge is not going to allow you to keep going back again and again and again. So if we're talking about the warrant for Bobby's computer, or the family, Gassy family,
Stevens computer, I think.
or Stevens computer, that frequently happens that they do a warrant looking for evidence of a potential murder. And
Stephen's computer in his living room. Keys found in the bedroom. Their whole.
The general question is if you can lay out probable cause and, you discover a new item or whatever, you can get multiple search warrants for the same residence. And that's very common.
I seem to recall that Griesbach actually treats this in his book, Indefensible. And he talks about the search warrant for the Avery property.
This statement right here, Travis, how much does this really matter? I declare under penalty and perjury that the foregoing is true and correct.
Yeah, all search warrants are sworn to and they're all under penalty of perjury. Now, if there's something in the search warrant that's not accurate, then
True.
you, as a defense, well, let me finish answering you what the remedy is. So if there's a lie in the search warrant affidavit, then you have what's called a Franks hearing, and that's Delaware v. Franks. And you tell the court, you have this hearing, say, look, and it's an evidentiary hearing, say, this is an absolute lie. The magistrate who approved this search warrant was lied to, and therefore you should determine that the warrant is illegal, and you should suppress everything seized under that warrant, along with the fruits of the poisonous tree of any items that were obtained at that search warrant. And then under the holding of Delaware v. Franks, what the judge has to do is listen to the evidentiary testimony at the pretrial hearing. And then if he determines that it was false, he has to line out all of the untrue statements. Then he has to look at what's left and determine if there's still probable cause with the part that's true. And if there is still probable cause, then the warrant is still valid and the seized evidence is still valid. And if there's no probable cause, then all of those items are suppressed. And so if there wasn't a Franks hearing at pretrial on Stephen's case, that issue would be waived. Now, what they really hit on, even on the direct appeal, is that you have to execute a search warrant within a reasonable amount of time. And they did execute that search warrant fairly quickly after it was signed. However, they remained on the property for 7-8 days, if I recall. And so that's what they contested fiercely, is that you basically had just a open-ended running search warrant, and that's not within the meaning of the Fourth Amendment. That's not a reasonable search and seizure to allow police to occupy a property for over a week. Looking around, they need to be specific. They need to be by warrant. They need to be by a neutral and detached magistrate. And then after the items are obtained and seized, they need to be, you need to file a return timely with the court. And so there is a remedy if there's lies or misrepresentations contained in a search warrant affidavit, but to my knowledge, that wasn't pursued in the case.
Well, the issue is that Mark Wiegert states that on November 3rd, 2005, at 5 p.m., Karen Halbach contacted the Calumet Sheriff's Department. That's a lie, because she called at 2:37 p.m. He then goes on to state that when she reported her missing, she stated that she had a dark blue RAV4. That's a lie. She clearly says dark green. Now, had he put what she truly said, the car they go and get wouldn't match the description of what they have in the warrant. Am I right or am I wrong?
No, you're right. They could have requested an evidentiary hearing on that, and then the judge would have had to listen to Wiegert and say, why is one green? Why is one blue? Wiegert would have had to testify. It was a simple mistake, and whatever he was going to say, and then the judge would have to determine whether it was intentional or not. Even if it's unintentional, it would still have to be possibly redacted. But if you don't make the motion, there's no error, and you move on. That's why it was never the subject of an appeal. I'm guessing, or it could have been looked at, and they determined that there was still enough information in there that the magistrate would have had probable cause to issue the warrant anyway, even without those two statements. But that is that's a fair point. That if you, but let's make it even. Let's change it to where he says in the affidavit it's a red car, and they seize a blue car, because like everybody else, they use word processors, right? A lot of the stuff is changed up, but a lot of it stays the same. And we run into that all the time, where they've used a previous affidavit in support of a search warrant, and because a lot of them are run of the mill. Let's just say it's a search for drugs inside of a house. They're almost cookie cutter, but they have to be careful. They can't be too cookie cutter, and they have to lay out the specific probable cause. But you see that all the time with addresses. It'll, be an address that has no relationship to the case whatsoever, and that could be fatally defective.
If you go through all the search warrant documents we have from the beginning to the end, why does the RAV4's year change from a 99 to a 98 to a 97 to a 94? And
it could be.
You got Thomas Fassbender. Thomas Fassbender states that things are being found on days that they weren't. And then you have another search warrant where John Dietering states that the same things were found on a different day.
Yeah, and it's either that the attorneys at the time weren't aware of it, or that they were aware of it, but didn't make a difference to them. It's hard to say, but they from the pretrial motions that I saw, those issues were never raised.
Jerry Buting and Dean Strang did not have the Calumet County Dispatch audio at all. And why is that we have the Calumet Dispatch calls, and there's over thousands, and then we go to Manitowoc and there's 79 for the same 9-day span.
That's a huge anomaly right
Yeah.
there as to what are they
And
hiding.
the whole day of November 4th is missing.
Well, didn't they say they were testing it for the upgrade?
Still should be recorded.
Yeah.
And I think what he's getting at, Travis, is just with all these anomalies, how does this get by the judges and the prosecutors? I mean, how does this stuff get by where they're not catching this? Is it that they didn't have all the information at the time, or are they hiding it? You know, from the people.
No, it's just not done like how you. How you think it normally would. So I don't know who they presented the search warrants to. That would help. But
Fox.
are
Fox.
all of them signed by Fox?
Yep. This is the events that take place. Griesbach, Rohr, and Ken Kratz show up on the property on the 5th. They then go with the search warrants to Judge Fox's residence and has them sign them at his house.
Okay, so that's the first set, but I'm trying to answer Jamie's question about how does this not get caught, and
how common is it for a special prosecutor and district attorney to be on the property that fast? Like
it depends on, in large counties, there's a prosecutor on call that they in Austin, for example, they've got a large enough DA's office. DA responds to every murder. There's a DA that's sent out and is out at the crime scene on every major crime. So it's not uncommon.
There is no crime scene.
You had a crime scene when her car's on that property. That's
yeah, but they didn't process it like a crime scene.
Well, I mean, we're going in circles. I'm just trying to tell you how the legal system works. I can't tell you, that there's not major problems in the investigation or whatnot. But Jamie asked, how could this possibly happen? Those judges, when they're reading the search warrant affidavit, one, that they don't keep a copy. They read it. They're reading through it. They're looking, okay, is this probable cause to search further? Okay, what do we have? Well, we have her vehicle on the property. We've got, I don't know, it's been a long time since I read that search warrant affidavit, the initial one, but they had probable cause with what they had. It's a very, very low standard. And so they signed that one. And then how many ever days or weeks or months later, they get another one, and the date on the RAV changes, or the year of the RAV changes, or the color, or Jamie, judges just don't keep a copy. They're not looking, and they don't remember.
Why did his lawyers not pay attention?
I don't know.
Is it common for?
Why didn't they inquire who entered the info into the CAD system for Manitowoc? Why didn't they subpoena the shifts for the dispatchers to determine when Lynn was working? There's so many things they could have done that they didn't do, like hire experts. They relied upon
Yeah, and now you're getting into the brief of Zellner, and she's covered that pretty carefully. But we'll have to wait and see. Unfortunately, Zellner hasn't even been able to get to an evidentiary hearing on, the most glaring thing she's covered.
Why?
But
The most important piece of this case, the two most important pieces in this case, the car, its contents, and the bones. Yeah.
Is it common, Travis, for some of these details to be in a large investigation like this, as you sort of trace the warrants through? Is it common that dates are off by a day, or you say this person found something when it was really that person? Is this run of the mill stuff, or is this stuff something where one agency would look at this and say, oh my God, well, all these errors are a terrible mistake and it's going to reflect badly on us?
Well, Jeff,
what's typical?
You were in conversations going way back to December of the year before, a year and a half ago, where I said, every case I've been involved in, there's, 2 or 3 little anomalies. Like I had a case where the murder weapon was clearly 1 caliber, and the shell casing that they picked up off the ground was a completely different caliber. That's a huge thing, and the state just waved it off as, oh, it's a transpositional error or a little mistake. But every case has a few, and then that's where I said, I'm up to, and from people like Millbilly and Jamie and you, Jeff, and Adrian and Allie, and I'm like, I'm up to 40 things, and then and then
you're not counting high enough.
and then there was a song, 80 more things, and this is no, it's not typical to have this many errors. And where this all came up is Adrian was going through CASO for the first time, and the Uyghur copied and pasted the firearms expert, called him and gave him a preliminary report, and then he copied and pasted, and he left in information from a previous entry he had made about where it looked like the gun was discovered during the first search warrant. So y'all remember that they found these key items, or they claim they found them, FK and FL, the bullets they found, the following March or April, whereas
March
the gun
1st,
that was
March 1st and 2nd. Yep.
Yeah, and then the initial 7-day search was in the late
November.
fall of November, and so it looked like, well, the way it was written, the way it was written, it said this item was seized and picked up during the search of November, which that clearly would have meant that guns were planted and bullets were planted. But it was clear after digging into it that it was just carrying over copying paste errors, and that the report of the firearms expert, he never said in his report that the item was seized at this strange time. But that's where I started counting, and then and we talked about it over and over again, stuff with regard to ping records and telephones and just a lot of strange stuff. And there's always a few things because humans make mistakes. Like, when I write stuff all the time, I'm making a mistake, but not like this.
From listening to all the audio that we have, or that I have listened to, and then reading these reports, it don't make sense. Things that you hear happening aren't even talked about, if not just ignored. And it happens every time.
Where are you to go to address all these concerns and things that we have about the case, to have someone take or address it or act on it, besides the attorney general or governor? Who do you go to next above the chain of command?
In terms of this specific case,
yeah.
Well, there's no one to really go to. What you do is
tell Zellner.
So Zellner's got the legal aspect, and then of course she's constrained by, what previous attorneys may have waived, except if it constitutes IAC, ineffectual assistance of counsel, then she can raise it. So she's done that with regard to not hiring experts and not doing certain things at the time of trial, and so on and so forth. At one time, she had a prosecutorial misconduct argument. That was in her motion for post-conviction relief, but she abandoned that claim in her brief. It's constantly evolving with her, like most post-conviction cases are. But so who are these? The buck stops with the elected sheriff and the elected DA and the elected attorney general. Who are they accountable to? They're accountable to the people. And so, what it comes down to is, are these serious errors or intentional conduct? You elect them out of office, you kick them out and get competent people in there. Then the question is it criminal? And you're not going to get anywhere with that with Wisconsin. And then, so the next question is it a intentional deprivation of rights, which would make it federal and FBI investigation and that sort of thing. And to get, you need a whole caliber above this type of thing to get the FBI interested in something like that. Ever since 9/11, their focus has been on terrorism and other things. It's hard to get them to come into a corruption case unless they have a clear paper trail on money.
Are you familiar with the Michael Bell case?
Yeah, well, vaguely familiar. I've heard things about that and the parallels with this case.
Well, yeah. Well, thanks to his father, they don't have outside investigations when it comes to police officer shootings and deaths.
What is that? Is that you said outside entities to do investigations?
Yes.
law enforcement and stuff like that?
Yes.
What about
We
position
kind of got off track of the Colburn stuff.
Yeah. The corruption
That
in
happens.
our judicial system, it happens every day. Not just this case, all cases.
There's a lot of
tons
corruption.
convicted people sitting in prison right now. They did for nothing.
Well, that's why Travis said the police union is funding this in the first place, and there's enough corruption in Wisconsin for Netflix documentation for the next 25 years.
Yeah, my speculation, just the way the timing, they ran it right up against the deadline. It just had all of the features of, it may just be some other big benefactor. I don't know, but it has the features of somebody like the police union coming in and agreeing to fund the costs, and then that police unions do that. But that's my speculation. And
then he got Greasebach jumping up saying, "I'll do it. I'll do it. I'll do it."
Right.
Yeah, it's a guaranteed payday.
What do you think is going to happen with this lawsuit?
I've been involved in some big time First Amendment media cases, and they're now that they've had to concede that he is a public figure, they're going to have an extremely difficult time making a case against Netflix. And then the issue on whether there's proper service, the evidentiary hearing got moved from March 6th to that week of July 4th. The parties have agreed that rather than that was a major loss for the plaintiff. They were going to have to bring all of these witnesses in from California, their process servers, so they've just decided, hey, let's just make everybody available to everybody else. And because you remember on the service of the process, the process server said, "Oh yeah, we served it on them. They live in a gated townhome, a pretty nice townhome that's gated, it's got surveillance." And they say, "Oh yeah, we served them on such and such a day." And their affidavit said, "No, I don't think you did. We were up visiting." One of them had a sick mom up in Northern California, and we were both up in Northern California with the sick mom, and I don't know what's going to happen with that. It's just going to have to be the judge is going to have to hear the testimony. It may even be that the process servers, the company, will produce people that talk to the attorneys for the producer defendants. They're the same attorneys, but it tells you how big this law firm is. So you got the lead attorneys on K Street in Washington, D.C., so that should tell you something. That's a big deal, a K Street lawyer. And then you've got their New York branch has got lawyers, and then their Minnesota branch has lawyers, and they've got like 5-6 lawyers, and they're representing all of the defendants, but they've divided up the legal issues, and so we'll just have to see. But the plaintiffs may say, hey, yeah, you can talk to process server Smith and process server Jones, and they just kind of go through it all. And sometimes it's just determined, okay, there's some mistakes here, or so on and so forth. And then they say, yeah, it looks like they got good service. Or it may be that just firms it up in their mind, and they say, okay, yeah, we don't need Smith at the evidentiary hearing. We're definitely going to need Jones. And, they'll have their evidentiary hearing, and it'll be quite interesting, and the judge will have to make the decision. Why this is so important is if they didn't get served, like the process server said they did,
Mm-hmm.
it's late service, and the statute of limitations applies. They're dismissed, and Netflix is the only defendant. And then, of course, Netflix has even more defenses than the producer defendants. They're going to have to show that Netflix knew. They knew that there was, it's actual malice, reckless disregard, or knowing falsity. They're going to have to show that somebody at Netflix knew it was untrue, and that yet they allowed it to be aired on their network despite the knowledge it was false.
Well, can I address something real quick?
Sure.
I thought that, like in the beginning, when this documentary was being made, it wasn't really conceived by Netflix. It was something that Riccardi and Demos did, and they even pitched the idea to HBO and several other providers, cable providers, and they decided
they pitched it to PBS, and PBS turned it down.
Yep. So it's not like, I mean, the documentary was like a brainstorm of Netflix. I mean, not until like the second season, but how are they to know what the producers of the show are going to edit and stuff before it coming out? So how would they be held liable for, say like what Colburn's trying to say, that they defamed him and
well, if I remember correctly, they already had 3 episodes already cut, ready to go, and then Netflix helped them with the other 7.
Well, they funded it. It's
yes,
pretty much
and
what
they were there and part of the production.
But I think before Colburn was actually had to admit that he was a public figure. Netflix did win awards for the editing of the series. So when you win awards for editing, you can hardly argue that you didn't do any editing. So
Good point.
So that's really was one of the the strong points I thought of. You can correct me if I'm wrong. For the original suit against Netflix, but now that Colburn's admitted that he's a public figure, again going back to the pictures that you see in the New York Times, on Fox News, of the politicians that they don't like, where they're making goofy faces, I don't think you have much of a leg to stand on.
Moving on, 04 asked the question that if Andrew or Andy had signed a waiver to be filmed and to be in the film, how could he go back and sue them?
Did he sign such a waiver? I don't know.
I don't think he signed a waiver. He's a public official, so it's not like, I mean, he has any reasonable expectation of privacy while being. Yeah, I mean, the film, much of the film that they gathered was already televised, or it's not like he cooperated.
That's too. The whole trial was broadcast online.
Yeah.
Yeah.
On the
it's
news
not like none of the officials, from what I know, agreed or anything like that to be part of the show. They all denied it.
Yeah, I didn't know that they did for sure either. She just asked the question, so I figured I'd post it here while we had.
Yeah, you try to get media releases. I think even folks that have been to rallies, they've asked for permission to be interviewed. But it's different in a documentary news piece I've been on TV dozens and dozens and dozens of times to either comment on my cases or other cases that, I can provide some sort of expertise on in general about it. Yeah, okay, this is what's going on in this trial. And they never ask for a release because by appearing on camera, I'm doing it voluntarily, and it's just a whole different realm as opposed to if I'm going to appear as an actor, and then you have all the acting unions and director unions and all that stuff. It's just a completely different thing. Now, some of you may have watched the documentary Behind the Curve, which is, it's not really about the theory of flat Earth. What it is about the people that belong to the flat Earth community, including YouTubers and everything. And there's one particular personality in that. He's claims he's the originator of doing YouTube broadcasts, and they have an annual convention, their first one, and he decides he's not going to participate. And the documentarians try and get him to come on camera, and they said, he had these demands, that he appear in 60% of the documentary, that he have, editing, the final say on editing choices, and on and on and on. And then and he said he wanted 10% of the movie, and he wanted this and that. And then you read that, and then below that kind of flashes up 4 or 5 seconds later. Unfortunately, we were unable to meet his demands. But, so he refused to appear on camera in an interview. And then, so exactly what y'all were saying in response to Moving On's question, if they had gotten Andy Colburn to come in and do an interview, like, for example, they had his civil attorneys on camera talking about the case. That was the unique thing that they got access to, is they were able to spend hours and hours with his former attorneys, even his former criminal defense attorney on the rape case, that woman. And they would have had to have signed releases. But Colburn, there's stuff from his deposition. It's him in court. It's him walking Brendan from courthouse to jail. It's him walking, he seemed to always want to walk these guys back and forth from jail. And which is why I figured he'd never going to win on the public official thing. He interjected himself substantially into the public by, that's a jailer's job, not somebody that's moved from the jail to to being a peace officer. That's you're just doing it for the publicity.
We also found out, Travis, that Stephen Avery was present during Colburn's deposition. So when during that time when Colburn, as shift commander, had to assign somebody to go out to the Avery house on the 3rd, who did he pick to go?
Himself.
Oh,
right.
What
I think Stephen. There may be one or two exceptions. I think Stephen, as is a plaintiff's right in every case, absent some very unusual circumstances. I had heard he was present at every deposition.
It states in the record that he is present.
Yep, and it will probably state on links he was present. It'll state at. I think he was present at every single deposition.
Except for the 2 that didn't happen. Because he was incarcerated. It's nice to be able to read all this stuff, though. That they.
Yeah. Now I noticed, and this is common. So when you attach a deposition transcript in support of a motion, you don't want to overburden the judge or the judge's law clerk, and so sometimes you just attach the relevant portions, and so the entire transcript wasn't there. And I can't remember if it was exhibit 13 or 16 that Christy pulled up, but it didn't look like it was the entire transcript. I may be
No, for
wrong
Mark
on that.
Maurer, no, the one for Mark is not the whole one. It's only
Nope.
part 2.
Yep, just like Greasebox too.
It's only part 2. But mentioning Greasebach and what we were talking about earlier, I did find it in Greasebach's deposition. He is asked about why he did not. So he won the election in September of 2002, and then he says for personal reasons he chose not to accept the position, but he did accept the position from the first of the year. So he was the district attorney from January to February, and then Rohrer was appointed by who was the governor at that time, Doyle, for March. So
Okay.
Griesbach was the district attorney. He does not go into why. He does say personal reasons, and I'm assuming it's Glenn doing the questioning, or Walter Kelly, whoever's doing the questioning, doesn't pry into the personal reasons. He just leaves it at personal reasons and moves on.
And I'm sure they knew what the personal reasons were.
Possibly.
You know, I mean,
it just doesn't need to get out there publicly to people.
Right. Right.
You know, and I've seen it where someone's wife got really ill, a child, you know, there are the typical reasons that things happen in people's lives that are just make it that, you know, you just can't fulfill the obligations of, you know, what you originally set out to do. And then, you know, there's other things too.
He appears to have gotten over it pretty quickly, since he found his way to the Abbey salvage yard on the 5th of November. It was an actively participated.
Quickly, I might add. You got there quickly.
The events of November
Very quickly.
5th into Colburn are quite strange, because he's supposed to be off of work. He's called in to do security at the checkpoint. He gets to the checkpoint, and then he is advised to go to the command post. And when he gets there, he's assigned to the search team going into Stephen Avery's residence. Then you hear them radio in for cameras and stuff like that, and Colborn says, "Oh, I have all that stuff in my patrol car. How convenient."
Jeff, can you explain? I want to answer the copyright question. How you know, I know about the GoFundMe, and I know, you know, they raised the money to purchase the transcripts and raise the money, but now what's up with who's asserting copyright and how's it coming up?
Well, I'm going to hand that question off to Christy, but
okay.
The two people that did that were Eric Banana Man, Eric C's Bananas on Twitter, and Julie Pompom, who you know from Eric Ozzie. And they were the ones, and congratulations and thanks to them for doing that hard work of organizing the GoFundMe campaign. But I guess that there is in my mind, a very strange caveat that came out. And I'm going to hand it to Christy or Millbilly to say what it was, because I don't happen to have it in front of me. I think it's very odd, what it is.
Well, I'm not sure I even quite understand, but I guess the question really is, how does this copyright work? Because like these specific depositions that we have right now, obviously it doesn't apply to those. We didn't get these through that. So I guess that's kind of the question. Jeff, am I missing something?
Yeah, but
here?
can you read him the statement that was associated with the information that we got from
with the email?
Banana Man?
Yeah, hang on.
Exactly.
Yeah, the email. Hang on. So the attachment on the email says, oh, damn it. Hang on. You may not share this link with anyone else. It can be tracked. You can download these deposition transcripts. You are also able to screenshot or quote sections of each transcript and use only enough for context and posts and discussion elsewhere on the internet, for example, on Reddit, Facebook, Twitter. You may not link, screenshot, or quote the full deposition transcript in full anywhere on the internet, in written work, or in any other media. Anyone who does this, despite this warning, leaves themselves open to being pursued by the copyright holder, Manuscript of Milwaukee. So what about these? How come that doesn't apply to these? How come these were able to be, is it because they were part of court paperwork? And it's not, I guess it's just a question. I mean,
there's no copyright to a deposition transcript. However, because I was trying to get word to, is it Banana Man?
yes, I believe so.
That, because I didn't know how difficult it was going to be for them to raise the, was it 4,000, correct?
Oh, I know it. It happened, and they raised it quickly because by the time I found out about the GoFundMe, they reached their limit. So they did it very quickly. So congratulations, good job, guys. I mean that from the bottom of my heart. Good job.
Yes.
Yeah. And so I think I was talking about this in foul play a little bit, texting that, you know, if it looked like it was going to be difficult to raise the 4,000, you know, I'd be happy to write a letter to Walt Kelly or the other civil attorney. You know, they have all the transcripts. I know Zellner has all the transcripts, but write to them and say, hey, can I get the transcripts? Now, every state's different on how deposition transcripts work. And it's to protect the court reporter. And they don't have a copyright per se, but this is how depositions work. So if I notice the deposition of...
Will the copyright be more on the videos than the...
no, there's no copyright on any of it. Okay. It's, you know, there's none of it. Copyright doesn't apply, but every state's got a set of statutes to protect the court reporters, but this is how it works. I noticed the deposition of Colburn. I'm obligated to pay the court reporter an appearance fee, which is like $50. So if the deponent no shows, that's their minimum. They get $50. And then I also have to order an original and a copy. And the original is usually $2.50, $3 a page. It varies all over the country. And then the copy is like $1, $1.50 a page. So a 2-hour deposition runs anywhere from $750 to $1,000 for the transcripts. These are the costs I'm talking about that it takes to litigate a case. You know, and you have 30, 40 depositions, you could easily have 50, 100,000 in just deposition for the court reporter, not all the other fees that you have to have. So what the other side does, and it's typically the plaintiffs who don't have a lot of money, if it's their client, the plaintiff, they'll always say, I don't need a copy and then they said, where should the transcript be sent to be reviewed and signed? And then the plaintiff's attorney will say, send it to my office. So when their client, Stephen Avery, comes into the office, he reviews it, signs it, and then they make a copy then, and they don't have to pay for a copy. But these are the things you have to do when you represent clients that don't have the money to pay costs. With witnesses, there's no way to do that. The witness, they ask the witness, where do you want to come into the court reporter's office to sign, or do you want me to send it to you to review and sign? And the witness will say what their preference is. And the only way to get a copy of that is to order it at the time of the deposition, and you pay the $1 or $1.50. Now, most states, the states I'm practice in and have practice in, California, Nevada, Idaho, Utah, Hawaii, Texas, there's no protection after that. You can run those copies off, attach them to any motions. There's no limitations. But I have heard of states where they protect the court reporters more. And if you go to the attorney whose case it is, let's just say you're a news reporter. Hey, can I get a transcript of Joe Blow? Can I get can we get some of the video? Walt, can we use your copies of the video depositions and for our documentary? Most states, there's no limitation on that whatsoever. But I've heard that there are states that it's still not protected under copyright, but the court reporter is allowed to charge for it, and an attorney is not supposed to release it. If they do, they have to compensate the court reporter. So, and there's another issue, Banana Man may have agreed contractually that in obtaining the copies of these transcripts, that he would limit the dissemination. And if he agreed to that contractually, then that's what that's what he's trying to do, is honor his part of the bargain. But there's no.
What does that mean, limit, though, Travis? Does that mean he's not going to do it at all? Does that mean he's going to limit it to the people who contributed? Or I
don't know. You saw his statement, and that statement may have come out of what he agreed with the court reporting company. So they may have said, yeah, we'll make these copies available to you, but you can't disseminate them. And, here's the agreement. And that if you do disseminate them, you could be liable for this. And so he's trying to protect himself. I don't know. It's a lot of speculation, but there's no.
All about money to me.
If I was to go through and read all these depositions that are included in the exhibits for his lawsuit, is that an issue?
Again, it's not an issue. It's not, you can look, it's on a government website. Yeah. And Jeff, you hit the nail on the head. It's in the public domain. It was never protected to begin with.
Right.
This is recording a conversation. Let's say you and I on the phone, and you record it. I don't have any copyright in that.
So if Kathleen Zellner sends out a tweet tomorrow that says, I have released all of the deposition information, even if she didn't, but let's just say she sends out that tweet, that all of a sudden anybody who has this can say, well, I got it from Kathleen Zellner's right? So she could fix this with a tweet.
Say hi to Pickles.
Hi, Pickles.
Well,
am I right about that?
Buckeye actually said so.
I'm working in the blind here. I don't know what they contractually obligated themselves to with the court reporting company. But yeah, it's all about money. that court reporter is and good, efficient, hardworking court reporters make a shitload of money. You know, they make really good money, but you know, they you know, the trial transcripts are no different. The court reporters typically are independent contractors. Sometimes they're county employees, but you know, they do it for agreed rates. But there's all kinds of manipulations in court reporting. I mean, the margins, they're never 1-inch margins. They're, you know, and they're never double spaced. You all are looking at condensed transcripts with 4 pages to the page. But I mean, look how little information there is on one page. I mean, and then every year it seems like they're less and less. Every year the margins seem to get wider. The typeface gets bigger. Because again, they charge by the page. So, you know, I bet I could take a transcript from, you know, the 80s when I started my career, and you look at the spacing and the pitch of the font and all the different things you can do to manipulate. And it wouldn't surprise me if you took deposition for deposition that the number of pages has increased by 25% with the same amount of words. But no, it is all about money. And, you know, the court reporters, you know, they'd always throw a little fit when the plaintiff's attorney said, yeah, I don't need a copy, but thanks. Oh, and send it to my office. Send the original to my office for signature, because they knew, you know, that, I don't want to say word cheated, but, you know, that deprived the court reporter of making money on what she would be able to charge for a copy. But just imagine if you're the court reporter, like the Hilton Fire case in Las Vegas I was on, there'd be 50 lawyers sitting in on a deposition, and they'd pass around this piece of paper. You know, you want a copy? And then it was just coming into vogue where you could order an ASCII disc, which was, you know, one of those 3.5-inch floppy disks, and it would be, all of the text would be in there from the deposition. And then people were just starting to market software packages where you could do super quick searches and whatnot.
How can you be so sure, Travis, that they didn't give you a copy of Oregon Trail back then, since you dated that disc right there?
Fuck you.
I knew that was coming.
No, I remember Jamie and I are old friends. Jamie and I are old friends.
I know.
I knew it was coming.
I can't be. Plus, you know, I can't even remember what I had for breakfast anymore. You know, it's just getting harder and harder. But you know, the stuff on copyright. But so I am not, please don't take what I'm saying as encouragement to go out, and if you've been given download access, to download and disseminate, because Banana Man may have, you know, reached an agreement with the court reporter company on what he would do or wouldn't do, and it may put him in a difficult position. They may have used the term copyright, but
so I've got a question for you, Travis. Just being that you just brought that up, a court reporting company. is court reporting now been privatized? It's not a government job.
Oh, it's in a civil litigation, it's all private, except while you're actually in the courtroom. And then in the federal system, they've pretty much switched to audio recording. And so now you don't have court reporters in the federal system, you have court recorders. And then by government regulation, they can, all they do is sit there, they make sure the microphones are all working and test them all. But all they do is put in, used to be a cassette tape. I'm sure it's digital now, but in all jurisdictions. But it started out, they'd put in a cassette, they test it, and then you'd order a copy of the cassette. But all of the depositions have been private since I started practicing law in the mid 80s. We hired court reporters, and you could just pull up your town. I don't care where you are, your town or county, Google court reporter, city of blank, or court reporter. And, depending on how large a jurisdiction, you're going to get a bunch of ads for nationwide companies, and then you're going to see a bunch of local ones. And that's what they do. I don't know if any of you have been deposed, if you've been, through a divorce proceeding, or you were a witness, or that, it wasn't in a courthouse, it was in a lawyer's office or conference room, and that young man or young lady sitting there with their machine, 90% of them have been female, because I think females have a unique ability to be able to do things with their hands, like typing. A court reporting machine is completely different than typing, but they can do that. And then they have this ability, they can listen to stuff, they can think about other things. And I think that's why 90% are female, but that's just the way it's always been. But no, they're private, and every firm pretty much develops a relationship with a court reporting firm, and they call up that firm and ask for a court reporter. And I know a lot about this because real early in my career, I dated a couple, and so that's where I learned what a scopus was. Anyone know what a scopus is?
No idea.
That's a proofreader that a court reporter uses. So they prepare the transcript, and then they always had a tape recorder as a backup. And then the scopus goes through and sees if anything doesn't make sense, and fast forwards to that portion of the deposition, and then listens to confirm what it is. But they're basically a proofreader for the court reporter, and busy court reporters have a scopus. And then I'd hear them bitch about, oh, this plaintiff's attorney, he never orders a copy, and or this one, never pays his bills, and you hear about all that stuff, but it's completely private.
Yeah, I think the issue on everyone's mind wasn't it didn't exist on the document itself, but like addressing and releasing the information that's contained in these documents to the public. There's like multiple ways that we could obtain these documents. How are they to know exactly where the documents came from? But but I don't know. I think that they like exploited this copyright infringement in a way just for like revenue for, you know, the what is it, manuscript, or it's just the same way that
Oh yeah, well, yeah, of course it is. But you know, you don't know. Manuscript may be two ladies, single moms, with 3 kids apiece.
right.
You know, so just don't jump to it. It is about money, but you know, that's why, you know, I was talking about, well, you know, who's doing that? And I've never conversed with Banana Man, but I was trying to say, well, if they can wait, I can try and see, because I know everybody's got the transcripts, and every jurisdiction I've been in, you know, it frequently happens. Hey, can you send me the transcript, you know, of Joe Smith that you took? And we email that stuff back and forth all the time. Or can you send me the trial transcript of this or that? Just happens frequently. And, you know, so I was trying to say, well, you know, I bet I can send something off to Walt, and then he would either tell me, hey, look, we got this goofy rule in Wisconsin that we can't send you a transcript unless you pay the statutory fee to the court reporter. And that may exist there also. But yeah, it's about money, but you know,
They're like trying to deter people basically from releasing the documents to others. You know what I mean? It's I don't agree with. I mean, I can understand about the loss of money and that they want to basically profit on every single person who gets it, but I mean, that's not always so.
Yeah, and it may be you know, a big nationwide corporation, and you know, I have no sympathy for them at all, but it's clearly they're trying to prevent making more money off of it. And if those got uploaded to a site similar to the Stephen Avery case.org, that's the correct address, right? StephenAveryCase.org is where practically every document's been, and all the transcripts are, and everything. Yeah, they're trying to do that, and they may even be trying to bamboozle people into thinking that oh, there's a copyright or whatnot. That's clearly what's going on, but I don't know what Banana Man agreed to, and if that would cause him problems. But your point's well taken. If there's a transcript attached to a document that's, you know, on the federal website for documents, and you know, I don't know what the public pays. Lawyers, we don't pay anything until it reaches a certain level, and then when we do, it's 10 cents a page. And then you're looking at getting transcripts that are 4 pages to a page, you know, so now you're down to 2.5 cents per page. There is nothing to prevent you all from downloading those documents and putting those up on a website. The U.S. government cannot claim a copyright. And so Supreme Court decisions are not copyrightable, so on and so forth. Now, if a company like West Publishing takes a Supreme Court decision and they bind it in a book and they spend money to come up with a keynote system and classify cases by different key numbers, which is the West reporting system, then that is copyrightable. And but the actual body of the decision or the order, that's public domain. About the only exception to that is like the NASA logo. That they do allow a copyright on, and I think that took a special act of Congress, but it used to be the worm logo, the big wide white letters, and now they've gone back to the world with that red thing. You all know it, but from what I understand, those are protected, but it's a huge exception to the rule that if it's produced by the government, there's no copyright. And questioning and answers aren't copyrightable. And whether it's in a deposition transcript or a video of the process, and that's why you see all of that probably in MAM 1 and MAM 2. It's no more copyrightable. All of the trials that you see televised. Now, what was copyrightable at one point, I think there was a European website that had transcripts of all of the MAMs episodes, at least the first season, and then those have since been taken down, and you have to go through one of those archive websites to pull those up. But there is a mix of original content in there, the graphics that explain what's going on, and the whole thing, even if it's snippets of what occurred in the public, but they went well beyond that. They went in and interviewed the civil lawyers, and they went in and interviewed the previous criminal defense attorney represented him on the sexual assault case, and they interviewed various pieces but then they interwove news segments and so on and so forth. And every television news station, for example, has a different policy on using an excerpt. And if it's a documentary, sometimes it's no fee. But if they're going to use it in a movie, they got to pay a much higher fee to get a clearance for it.
Yeah.
Well, I do think there is some type of merit to the copyright infringement, and that's if people took these documents and they used it for personal profit and gain.
So that could be an issue.
Yes, that could be an issue, but I mean, nobody's really looking to profit it on a way to make money, but basically just spread awareness and bring out the truth. Right.
Yeah. So it's if you want a copy of this, send me $5 and I'll send you a transcript. That could be a problem. In the normal way that things work, like if I asked Walt Kelly, hey, can you send me all your transcripts from that? It's yeah, go ahead. And there's nothing to prevent me from sharing that with anybody else I want. There's nothing that would prevent you all from taking the transcripts that you do have attached to this motion and doing whatever you want with them. And of course, they're they're marked on the bottom. When the clerk scans them, it puts that blue watermark at the bottom that references the document number and the case number, and but I wouldn't want to encourage anybody to that was given access, and I presume people that contributed to the GoFundMe maybe were given the access to a shared server of some type based on the statement you read to me. But as I recall, they were going to get the transcripts, and then depending on how much info was available in the transcripts, and they were going to consider getting the videos. And then that's a completely separate person, by the way. A lot of times they may be with the same company. Frequently they're with a different company, and they charge a higher flat fee to come in, and then they charge you for a copy of the video. And so I think I don't mean to speak for him, but I bet he's like, yeah, I hope you all honor this, because they were going to be looking at what happened with these transcripts when it came time to, if there were any videos we wanted to order, and that, if people just started sharing this stuff freely, it would blow his chance to get the videos. But I don't know if you noticed, the videos are filed with the federal clerk.
I don't know that.
It's on the exhibit list Christy was reading earlier, and so this isn't any earth-shattering news. Any of you could contact that clerk's office and ask them to burn a copy. I don't know what format they're in, DVD, whatever.
You could actually go to the clerk of court's office yourself and request to look at these documents.
Are they released out yet, or are they still waiting?
What? For what?
That there's videos.
They're on the exhibit list. They were lodged with the court, both the video version of the deposition and the transcript.
Mm-hmm.
So does somebody have a copy of the video?
The clerk.
I was wondering if anybody supporter-wise had gotten it.
Not yet. Just USA Today when they put the deposition videos out on YouTube.
Are those still up, Millbilly, or have they been taken down?
No, they're still up. They're on quite a few channels.
And how many depositions do they have up?
Peterson, Couché, Link, Colburn, Roar. I think that's it.
And when did they put those up? Years ago or what?
Like 4 years ago, something like that.
Okay. Yeah, there's no copyright in any of that stuff. If there was, you'd be hearing about it. You guys know how YouTube is with copyright.
Mm-hmm.
But there's having these transcripts is in the form that Banana Man got. What's really helpful about the format that he got is those are searchable PDFs. The exhibits you all have, you could convert it to searchable PDF, but it's not going to be. So if you're doing serious research, and for example, you have all the transcripts and you're trying to find out what's the deal with this resignation of Griesbach, and you can see how he terms it, and you can punch those search terms in, just like every single one of you have done with queso, and on and on and on. And you all know the difference between hunting through a non-text searchable PDF document, an optical document, for example, CASO, and then, when it was converted to searchable, how much easier it made your life. And so this was not a waste of money by any stretch of the imagination. It was a really good move, and I again, I'm not encouraging anybody. I didn't know the videos were up on YouTube.
Well, I thank you for coming on here and talking about this.
I apologize for stealing your all show. It wasn't my intent.
No, it was
we can get some of
fine.
your time. It was great.
Before we move on, though, I just want to let everybody know that I just posted it down there. You can request a link to the Google Drive that has all the depositions in it. I saw Debbie write that she wanted to read Sandra Morris's deposition. It's in there. I would give it to you, but I can't. It was asked not to share the link. But if you email averytranscripts@gmail.com and ask for access to the link, I've been told that it's pretty quick. I did get a response quite quickly. Within, I think, 2 minutes, I had my link. They are searchable. We just can't post them right now. So I'm going to respect everybody's wishes. I mean, I'm not trying to get anybody in trouble. I think that it's amazing that we got these. I know there's
reached out to get them yet. All the stuff I've looked at has been from the exhibits from Colburn's lawsuit.
Right. I haven't had a chance to look at any of them either. I've been busy. I was preparing for this. I was reading stuff. I was doing other stuff, but they're out there. So again, it's averytranscripts@gmail.com. Just request access to the link and you'll get an email back, and then you will be able to have access to all. I believe there's 35 depositions in total.
Yep.
And just to reiterate and to clarify, I'm encouraging all of you that request that access, and if you get it, to abide by
absolutely
whatever terms they specify. We may not agree with it philosophically or fundamentally, but those issues may get sorted out over time. More and more depositions may be attached as exhibits, and that court reporter company knows that anybody can do anything. And of course, if you put up the federal court document transcripts, they have that blue thing at the bottom. But these folks put a tremendous amount of work into funding it and getting the court reporter company to share that with them, and that helps all supporters and all researchers. And so I would encourage you to abide by that, even though, and I understand the fundamental differences of why they are insisting on this. So I'm not saying, even though legally there's a prohibition, I think there's a moral obligation to support fellow supporter and what agreement they had, and it'll eventually all get out there. And then clearly even the statement that Christy read, if you all find significant issues like this thing with him resigning, it says, from the way my understanding of the reading was, that you can post small excerpts to defend your position, or you can just cite the page and the line numbers like we do with the briefs. But so there's a lot of good that's going to come from this, even if it's constrained a little bit. And I think
Travis,
all that.
If I could interject quickly, what do you think? Coming at it from a lawyer's perspective, what is that information that the sort of the layman researcher like myself might try and uncover, reading through these documents, that would be of most help to Kathleen Zellner? What might we find the most surprising? You know what I mean? I think there's things that we know. What are those things that we don't know?
Okay, so that's an excellent question, Jeff. Thank you for that. I was actually thinking about that when it came up in your all's the Foul Play Discord, and there was talk about, hey, they're going to try and get. I think y'all posted something from Banana Man that said, hey, we've worked out this agreement with the court reporting company, and we're going to start with the transcripts and maybe look at videos later. And I was thinking to myself, okay, let's see. And, you know, it's like a lot of things. You're just not going to know until you go through it. But I think we can think of some things. Some of them may have already been exposed in Making Murderer 1 and or 2, more number 1, where they were showing the video portions. But as I'm sure all of you are aware by now, they had so much material, and to even narrow it down, I think they started the criminal aspect of it, by the third episode, and the first 2 covered the civil case, his exoneration in the civil case. But by episode 3, we're into Teresa's missing. So there's no way they could have covered all of the stuff in the lawsuit. And they were using the 2 civil attorneys to focus on, what the key problems were. This letter being written the day after, or memo being written by Colburn the day after Stephen's release. But there could be 100 more things like that. But that was obviously a huge bombshell. And then but this is what I would recommend, Jeff, to answer your question. I would get a copy, and it's one of the exhibits that's available from the Netflix case, and the second motion to dismiss is the Wisconsin Department of Justice report. And that's one of the things the civil attorneys utilized that really helped them in the case. Is the DOJ report. The investigators were paraphrasing what all of these people told them. That woman who was a reserve officer that was involved in the and she says, "Oh, that sounds like Stephen Avery."
Dvorak,
yes.
Yeah, Trudy Dvorak.
But I would familiarize yourself with the DOJ report, because in Mann, if you'll recall, that's what they were pounding them on. Is they said, well, the investigator so-and-so says that you said this, and then she's trying to say, no, those aren't my words. Well, it says you said that Stephen Avery was dirty. No, I don't recall saying that. You all are familiar with it. Number one, I'd familiarize yourself with that report again before going through the transcripts. And then the way I always go in looking at a case, for whatever reason, whether it's, maybe I'm looking at it to file an appeal, or I typically try and go at least the first time in the chronological order that the depositions were taken. Now, that's just my style. That's not anything etched in stone, but you kind of get, cases have flows. I know that's weird, but cases ebb and flow. And it will kind of give you the sense of how it's ebbing and flowing. It doesn't make logical sense. You depose witnesses in whatever order you can depose them in, and that's just the way it is. Now, here's a question. Was Stephen deposed in that case by the defense? Was Stephen's deposition taken?
I don't believe so.
I don't think so.
No.
No.
That's pretty damn odd. Pretty odd. Because the way if we're on the defense, we usually insist that the plaintiff's deposition be taken first. Because the defense usually has money. They're paid by an insurance company or a company of some sort.
I haven't looked at all of them yet, so I know there's over 30 of them. So,
Are you talking about Colburn's case? Are you talking about the Penny Bernstein case? Or are you talking about
Bernstein? The depositions from the Stevens case against the county. That's where all these depositions are from, right?
yes, that's right.
Avery versus Manitowoc County, correct?
Yep.
And the three individuals Jeff knew right off the top of his head. That's what case I'm talking about.
And the county, they were all liable.
I only knew two of them, and Jamie knew the third one, just to set the record straight. I knew it was Kasurek and Vogel, but I didn't know who the third one was.
Peterson.
You knew
So
it didn't come to you right
Real
away.
Billy knew all three. Millipedia, that's what we call them around here.
Millipedia.
All you guys for attending me, joining me with this, and thank you, Travis, for coming in. You were.
I'm sorry I stole your show, Billy. I really
No,
am.
it was great.
It actually helped because the whole point was to I mean, there's still more stuff that we wanted to go over as far as the depositions, but it helped just understanding a little bit more about it. So I'm glad you came on, Travis.
I really appreciate you. But you've always very generous with your time when it's come to questions. I don't think people realize there's not a lot of free legal help that's available. Not I'm trying to say that you should come to Travis with all your free legal questions, but we've come to him with some pretty serious questions when it's come to interacting with certain people. He's always been extremely generous with his time, as he was tonight. So thank you very much, Travis, for all that you've done.
Absolutely.
Yes,
Absolutely. Thank you.
Yeah, it's my pleasure. And, several of you know how to get a hold of me. You have my email. And if, something comes up in a deposition and you want to talk about it more in this format or whatever, you'll know you can call on me. I think I've corresponded with all of you at one time or the other, and either by email or Discord or whatever. But I appreciate what y'all are doing. It's important.
Thank you.
Got to keep talking about it.
Got to keep talking about it, one way or the other.
Well, thank you, everybody, and
Have a good night. Thank you, everybody, for joining us.
Thank you very much. Yep.
Thank you.
Catch you all later.
Bye-bye. Good night. Thanks for having me. Y'all take care.
Bye-bye.
Bye-bye.
Thank you, Travis.